Gentlemen, kindly take a look at this. Attorney John Detton, who represents XRP, is concerned about the possibility of a rug pull by the SEC in advance of the approval of a spot Bitcoin exchange traded fund. The XRP lawyer, John, is of the opinion that and feels that there is a possibility that the SEC will pull ahead of the approval of the spot BTC ET. However, there are still situations and developments concerning the Bitcoin markets that are really exciting. A substantial request has been made in this regard by the Securities and Exchange Commission Secretary in the context of a lawsuit that has been filed against Terraform Labs and its co-founder. They have requested that the court rule whether or not a particular cryptocurrency asset is a security rather than allowing a jury to assess whether or not the asset in question is comparable to securities. The motion for the court process that SI submitted on December 4th in the Southern District of New York, arguing that the jury should decide the legal question of whether or not Bitcoin is classed as securities according to the recommendations of the commission, rather than a factual one was submitted. Authorities from the Securities and Exchange Commission assert that the lawsuit filed against Terraform Labs has created a discussion over whether or not the Howey test need to be utilized in order to categorize some cryptocurrencies as securities. It is indisputably true that the defendant's sales of crypto assets involve financial investments and joint ventures with the express intention of collecting gains from the wages of others, as stated by representatives of the CS. This is the statement that was made in defense of the situation. While there is no debate regarding the facts in this case, the jurors may be questioned in order to resolve any differences regarding significant particulars. Conflict between the cryptocurrency market and the Securities and Exchange Commission of America has resulted in the deciding to classify a number of cryptocurrencies as securities and initiating enforcement actions against Coinbase and Binance. In July, a federal judge ruled in a lawsuit against Ripple the XRP did not have to be classified as a security. Decision meant that the Securities and Exchange Commission was able to retract its claims against Brad Garlinghouse, the CEO of Ripple Labs, and Chris Larsen. The role that the Securities and Exchange Commission ought to play in the legal regulation of cryptocurrency assets is currently the subject of a disagreement between both legislators and regulators. In the United States, the topic of which virtual currencies will be classified as securities or commodities is at the center of the argument. According to a number of sources, the Securities and Exchange Commission may soon decide whether or not to allow a product that is being traded on a spot cryptocurrency exchange for the very first time. Johnny Detton, the developer of crypto law and an attorney who specializes in XRP, is making headlines. A post that was made by a former Secretary of State, John Reed Stark, was reposted on X because Detton believed it was intriguing. An increasing number of people are becoming interested in the imminent approval date of a spot Bitcoin exchange traded fund, which is causing a large bull market to emerge. Bitcoin broke beyond the $44,000 barrier after a period of 19 months, according to experts who anticipate that a spot Bitcoin exchange traded fund could make its debut between December 7 and December. In the middle of these speculations, John Reed Stark has introduced an unpleasant element of spice. An expert in law saw that the SEC's allegation that language in the recent BlackRock is shares. This was revealed in John Detton's response to Stark's comment. In light of the fact that it is quite likely that the application would be rejected, it will be challenging to trade Bitcoin on exchanges if the Securities and Exchange Commission decides that the digital asset is a security. Additionally, this may attract the attention of regulatory authorities, which may result in Bitcoin losing some of its current popularity. John Reed Stark takes into consideration two different possibilities, but he admits that a 90% possibility that the Securities and Exchange Commission approving a Bitcoin spot exchange traded fund looks arbitrary. He brought up the fact that the initiatives brought to light significant concerns regarding the impact on investors. In addition, he is critical of the non-traditional approach used by Sex Chair Gensler, which is characterized by a disrespect for the various points of view that exist inside the agency. Furthermore, he calls the attention to Gensler's earlier involvement in legal concerns, such as his lawsuit against Covington Burling and his sponsorship of disputed regulations, replying to Stark's detailed analysis of C.C. Gensler's intuition. John Detton is aware of a potential roadblock that may arise. Reportedly, there is a possibility of a hidden backlash occurring despite the fact that there is a 90% chance that spot Bitcoin adoption will drive up the price of the cryptocurrency. The tough attitude that Sec Gensler takes on the cryptocurrency was clarified by Detton, who referred to the likely consequence of the spot Bitcoin ETH denial as a regulatory rug pull. The developer of Bitcoin Core claims that Bitcoin, ordinals, and BR20 will be eliminated, that they will be approved, and that they will be allowed permission to identify Bitcoin ETF. When the statements were made, the price of Bitcoin had already surpassed $44,000 and the market was in an extraordinarily optimistic state. It is still up in the air whether or not spot Bitcoin exchange traded funds will be authorized. Bloomberg analyst, who was the original author of Joe's essay, presented an additional hypothesis. Earlier assertions made by him indicate that there is a possibility that a spot approval for Bitcoin might take place somewhere around the 10th of December. In addition, he predicted that the spot Bitcoin exchange traded fund offered despite the turmoil that has been occurring in the market. There is a possibility that Bitcoin will swiftly surpass $50,000 if a spot ETF is approved. However, if the Securities and Exchange Commission rejects all papers that designate the cryptocurrency as a security, it will be difficult for the price of Bitcoin to return to its previous level. It has been requested by the United States Securities and Exchange Commission that the judge who is presiding over the legal action brought by Terraform Labs assess whether or not the company issued and sold securities that were not registered or registered. The Securities and Exchange Commission maintains that a jury should not be responsible for determining the status of securities. There is no question that the jury is tasked with determining on the status of securities. In an argument that was submitted to the United States District Court for the Southern District of New York, the second party argued that the determination of whether or not particular cryptocurrency assets are securities is a legal question that must be decided by the court and not a factual decision that should be left up to the audience. According to the Securities and Exchange Commission, the question of whether or not any of the cryptocurrencies involved in the Terraform case satisfied the requirements of the Howey test for security sparked a discourse about the topic. The fact that the defendants' crypto asset offerings consist of financial investments made in a joint venture with the expectation of receiving financial returns for their labor is an irrefutable reality, as stated in the filing that was submitted by the SEC. Although the court may ask the jury questions in order to settle the factual conflicts that exist over the fundamental features of this case, there are no factual disagreements regarding these aspects. There are no factual disagreements or disagreements regarding the terms of the offers and sales, the way in which the defendants' cryptocurrency assets were sold, or the assertions made by the defendants, as well as their marketing materials and promotional efforts. In addition, the Securities and Exchange Commission asserts that Terra failed to address the SEC's accusation that it marketed and sold cryptocurrencies as unregistered securities in its opposition petition for summary judgment. According to the legal team that is representing the Supreme Court of the United States, the fact that has not been contested and that has been brought up in earlier filings is adequate to fulfill the governing legal standard, and the judge ought to make a decision regarding this matter. That's all for now.